Building 4 is not. So we know that Building 2 should not exceed 8 units per building. Now, if you saw for the second that they were talking about residential, you have to ask why in December, almost 2 months after the closing, all of a sudden, is there a discussion or talk about converting to condominium units if, as City Center says, that was discussed ahead of time? It could not have been, because they didn't even have approval at that point, if that's what this is talking about. Now, the design releases. It was 40, 42, and 43. The design releases are those documents from Falk Design. Falk Design is their architect, remember, it's their architect. And what do they say? In June of 2006, June the 27th of 2006, we're basically 9 months into the loan at this point. And as far as it pertains to building number 2, you see residential. There's 3 M&B. Remember, M stands for merchant, B stands for business, R stands for residential. For the first time in a design release in June of 2006, we see a residential release from the state of Indiana. If you look back in November of 2005, building number 3, M&B, merchant, business. If we look at the next exhibit, December the 5th of 2005, building number 2, the release says, building number 2, B and M. We know December the 5th of 2005, they obtained a release for business and merchant use from the state of Indiana. It's not until the following June that they get a release for residential purposes. That means in between those 2 dates, at some point they changed the use. And they didn't produce a document to let us know when. I told them. But there's no documents. Every time you ask for a document, there's no documents to specify when. Now, if you look at the next exhibit, it's that December letter again, telling us that buildings 2, 3, and 4. So we know for this letter to be issued and for the state to issue a release, it had to be after the closing. There's no way it could have been before that. If you look at the next exhibit, we know, because one of the things that the parties, especially City Center, keeps harping on is they knew. Well, you can't say they knew and I didn't when there's documents staring you in the face to tell you what you know. We know that on October the 18th of 2005 in Exhibit 44K, there was an email from Brian Speck to Richard Plank. And he said in that email, here are the tentative copies of the loan documents. He gave him a copy of that loan agreement on October the 18th, 3 days before the closing, and 6 days, I believe, or 3 days before execution, 6 days before the funds were dispersed. He had time, and he desired, to have his counsel review it. He had time to review it himself. There was no lack of time. There was no rush. These weren't documents that were just thrust upon him and said, sign or else that's it. What other evidence do we have of residential use? We have the leases. Remember, Rich testified, Mr. Plank testified on direct exam, I gave him to Brian, I gave him to Brian, I gave him to Brian. He should have had him, they lost him, Joanne couldn't find him. Well, we know that the lease with Richard H. Plank, his son, was signed on June 1st of 2006. Well, Brian was long gone by then. We all know that. And Joanne was well on her way into getting into the file. So that was June 1st. He was going to pay $2,000 a month for 2,000 square feet pursuant to the lease. And the ostensible use was residence. He was going to live there, so the lease said. We know that he never moved in, even though He did sign it, as did his father. They both signed it. Submitted it to the bank, intending for the bank to rely upon that as justification for their leasing requirements. He also entered into a lease with himself as tenant, dated the same date. That lease has the same use. It has a rent provision that was never paid, as we know, and he signed both on behalf of himself and on behalf of City Center. And then we have a lease with Rachel Plank, coincidentally executed the same day, June 1st of 2006 again. We know that she didn't pay $2,000 a month rent when she testified. She didn't know anything about that. I think she said she paid $600 a month or something to that effect. And when Mr. Plank was asked why she paid less, well, because it's my daughter. I forgave that, or something to that effect. So, and we know, well, the use was left blank in that particular lease. That was never explained why. She signed it. It was presented to the bank on sometime after June 1st, for an explanation of the leasing requirements for the bank. And then finally, Anthony Santa Caterina signed a lease June 1st, once again, on the same date, for the same use, for residence use, where he was going to pay $1,241 a month, where we know after the fact that he only paid $835 a month based upon cross-examination of counsel and Mr. Larson. We explored that yesterday. So he paid nowhere near that. And don't forget, each of these documents had attached to it a rider number 40. Remember that? Rider number 4 said prohibited uses. And the prohibited uses were residents. These documents were internally inconsistent, and yet they asked the bank to rely on these leases for residents, non-residents all at the same time. Dated just 2 days after Joanne Steiger's second email. Remember, there's one dated May 16th and one dated May 30th. 2 days after Joanne said, hey, there's no LOIs here, there's no leases here, where are they? Well, I gave them to you. Well, how could they have possibly have been given to the bank if they didn't exist yet? Because they didn't exist, right? Now, Rachel Plank signed a letter of intent dated March 1, 2006 to enter into a purchase agreement for a condominium unit for $150,000. She had absolutely no recall or recollection of ever having done so, and said she signed because she was helping out her father. And I don't doubt that for a second. I believe she truly did sign that to help out her father. That's not the issue. The issue was this something that the bank could accept to meet the terms of the construction loan agreement? I'm going to show you in a second why it couldn't be. Then there are the architect reports. Because, remember, the architect, this is Falk Design's architect reports. These are the reports from their own architect and engineering company. On Friday, June the 9th, 2006, after these leases were purportedly signed, the architect reports on building number 2, a spec condo. Remember, spec condo, there was testimony of speculation. It's built for speculation, for perhaps resale. At this point, even Falk Design Group didn't know the purpose of that spec condo. Again, they reference it as a spec condo on June 9th, 2006. Approximately 1 week later, on June the 16th, 2006, again, they're referring to it as the spec condo, and there's work going on. So we know as of June the 16th, 2006, Falk Design did not know the use to which this condo was going to be put. On the next page, again, reference to June 16th, spec condo. So, in their mind, at least, according to this document, they don't know its intended purpose. Finally, on July the 17th of 2006, they refer to Tony's future condo. So, sometime between June 16th and July, someone's told Falk Design Group that Tony, probably Tony Santa Caterina, is going to move into a spec condo. All right. Now, What does the blue memo say about residential use? You can take your time. It's Exhibit 2. Take your time and go through it. You're not going to find any reference to any residential use in Phase 1 of this project, the first 4 buildings, which is all this contract applied to, the 4 buildings. There's no discussion at all about any one of those buildings in the first phase ever being a residential building. And the very first page, under purpose, funds will be used to construct the first floor of the commercial buildings comprising of retail on the first floor and office space on the second floor. That's kind of hard to see, but I'm reading it verbatim. On page 6, they talk about the 2 scenarios are presented. One with full lease up of the first floor retail and minimal leasing of the second floor office space, and the other with a higher retail and a higher office space occupancy. That was the write-up. And remember, Brian Speck prepared this. Supposedly, he was the one that was given all of the information. Right underneath that, they talk about full leasing of the retail space and absorption of the upstairs office space. And then on the next page, page 7, he talks about office and retail space. Once again, up here, office and retail space. You won't find any proposed use for a residential building in that blue memo. It doesn't exist. Even credit, he reports, credit has some discomfort with the real estate. Retail on the first floor, office on the second floor. And then he talks about, and we'll get into this in a second, because a key component that gives comfort to credit is pre-sale of Building 2. So Building 2 is going to be pre-sold. We'll talk about that in a second. What does the loan agreement say? The loan agreement says, and you've seen it time and time again throughout this trial, prior to the construction of any building, it's 1.3E. I'm not going to rehash it here again for you. You know what it says. You've read it yourselves. You know what the requirements were. 50% of the building being built had to be pre-leased. Then, once it was 75% pre-leased, and the second building was 50% pre-leased, then they could start construction of the second building. That's what it says. It's clear. And remember, of that 50%, 25% had to be office, upstairs. It's clear. It's unambiguous. There's no interpretation needed for that document. What does the commitment letter say? Oh, let me just digress for a second. The project is defined in the construction loan agreement as to the project that we're talking about. If you read that closely, it basically tracks all of these other documents. And it says the project consists of a 4-building, upstairs, downstairs, retail, and office. There's no mention of residential in there anywhere. The commitment letter, dated October the 12th, 2005. Under purpose, once again, the funds to be used to construct the first floor of the commercial buildings comprising retail on the first floor and office space on the second floor. This is dated and was sent out October the 12th, 2005. Brian Speck said he delivered this personally in hand. So now we're at the 12th, document signed on the 24th. We're 9 days ahead of time and 12 days before the closing. City Center had the opportunity, had they so desired, to read and disagree with the commitment letter. They had the opportunity, had they so desired, to read and disagree with the loan documents given to them on the 18th. They had the opportunity, if they so desired, to read and not sign the documents on October 21st. They could have acted all the way up until the 24th when that first disbursement was made, and yet no one ever objected. Remember, they had attorneys. You saw in the Ledger Exhibit 33, they were paying lawyers to do work. They had lawyers, they had accountants, they had people that could have looked at this stuff. You just can't bury your head in the sand and say, sorry, I didn't read it, I'm not bound by it. Let's get to the next one. The contract has definitions. it defines what a building is. A building is erected on the real property for the purpose of leasing to office or retail tenants. These terms are very strictly defined here. Office lease means used for professional services. Retail lease means leased space for retail sales. You won't find a definition permitting residential use in that entire contract, ladies and gentlemen. More importantly, this is key. No one's talked about it up until now. Negative covenants. It's in Article 7.6. This is what it reads. The borrower, and I'm going to paraphrase the lead into this paragraph because it's on a separate page. It says, the borrower shall not. It's a negative covenant. It's what they're not allowed to do. Shall not directly or indirectly lease any property to any partner, stockholder, director, officer, agent, or employee of the borrower or any relative thereof. It couldn't be more clear. That means you can't lease to Rachel. That means you can't lease to Rich. That means you can't lease to Rick. That means you can't lease to Anthony, Tony. And most importantly, it means you can't lease to Joanne. It was strictly prohibited by a negative covenant in the construction loan agreement. But you wouldn't know it was in there if you didn't read the contract and never bothered to do so. The judge is going to instruct you about when a breach of contract occurs. He's going to tell you it occurs when a party fails to perform all of the duties it agreed to do or places itself in a position where it's unable to perform its obligations. That's exactly what City Center did. It placed itself in a position and it failed to perform all of the duties that it agreed to do. We just walked through them. There were leasing requirements, there were negative covenants. They violated both of them from the get-go. Well, not from the get-go necessarily, because remember, the leases didn't come until June. They were trying to do retail leases. That should be enough by itself to put an end to this. But there are further issues that arose. One that you've heard about is the restaurant banquet facility, and you saw a letter of intent from Joanne Botterman, owner, to lease. She signed it, Joanne Botterman. Go back for just a second. Please note on page 2, the top line, this letter of intent is not a binding contract. It was not binding at any rate. So, and then she signs as Botterman, and consistent with her newfound freedom, recall, the restaurant facility, so the bank thought was going to be sold. You saw it in the blue memo just a second ago. You saw it in the email dated September the 28th of 2005. Now, this is before the closing, all right? And Brian Speck is looking for an update from Rich. Can you give me an update on leasing activity? I know you are going to occupy the second building with the restaurant and banquet facility. Where are you on leasing the first building, as well as any other building that you are going to sell? Well, you are going to sell obviously refers to the fact that you're going to sell the second building. You're going to occupy it and sell. The bank doesn't have a negative covenant saying you can't sell your property off and pay us down. That's what they prefer. Remember, this was a construction loan. It only lasted 2 years. It had a finite end. At the end of 2 years, they had to either pay it off or get other financing. And Fifth Third Bank wasn't obligated to do that. You won't see an obligation in that agreement anywhere that says, we'll refinance this for you. That was their obligation. And at the end of 2 years, they had to have the money available to do that. If you look at the blue memo, again, Brian Speck prepared. Mr. Plank has entered into a sale contract for the second building. Where else would that information come from, except from city center? You can't say they knew about this, they knew about that, and say they only knew about the things that benefit me. You also have to, in fairness, say they also knew about the things that don't benefit me too. And those are in black and white. All right? Now, second page, again, he talks about it. He talks about, up in this section, he talks about pay down after sale of the second building. And then on the last page, he talks again about, right in this section, pre-sale of building number 2. It was quick. 3 times in that document, he said, this building's going to be sold. There's only one place to get that information. That's from City Center. Okay? Now, let's talk about this bottom lease. Dated first, we know that Joanna Plank, also known as Botterman, is the owner, tenant. It was signed as such, Botterman, owner, tenant. It's somewhat perplexing. Jump ahead of one more slide. It's somewhat perplexing that on the same date that this lease is signed, there's a letter of intent signed. That's highly unusual. Why would you sign a letter saying, I intend to do this, but I'm not bound, and yet on the same date sign a lease saying, I am bound? You know, I don't know what to make of it, what you will. It just seems odd that that would happen. I don't know how it could happen. Let's skip ahead to the contract, because I'm not going to rehash what everyone said during the trial. You were sitting here taking notes. I was in and out of here. Your memory, your notes are probably better than mine. And so we'll rely on your collective memories as to what the testimony was out of this seat, so as not to garble things up. All right? Let's look at the contract, Exhibit 4. We know under 1.3 B and F, again, the leasing requirements have to be met before they can start building number 2, or second building number 6. And we also know that there's a negative covenant prohibiting transactions with insiders, and the insider is Joanna Botterman Plank. She's defined clearly as an insider. Look, it was a prohibited lease. You can't do it. Explain. Have City Center explain to you how Joanne Botterman, or Rick Plank, or Rachel Plank, or Tony Santa Catarina doesn't come under that definition of that contract. Breach of contract occurs when, again, this is the law. It's the same law. It's going to be the same instruction throughout. When they fail to perform their duties they agreed to do. Well, if you can't use a lease, I don't care if it's for 100% of the building. It's not arm's length. And remember what the testimony was why they don't accept non-arm's length leases? It's because sometimes freedoms are given to people. You know, are you really going to kick your daughter out of the apartment that you own if she doesn't pay her rent? Or she's, you know, Dad, I'm a little short this month. Oh, I can only pay $300. I can only pay $450. No. Remember, how do you value this? You value it with a stream of income. You value it from the leases. Even Dennis Larson agrees on that. And if the leases aren't fully paid, you don't have a stream of income. And if you don't have a stream of income, you can't service the debt. And if you can't service the debt, the loan goes into default. Let's talk a second about whether or not the leasing requirements were met. And we're going to do this at 2 points in time. One January 30th, 2006. And the reason we choose that date is in 1st Indiana, Exhibit 13, on base stat page 94. That's the first mention in 1st Indiana's inspecting architect reports that they say some building is going on in building number 6. That's the first time it shows up. Now, even though it's noted on January 30th, it's dated March 6th. So the bank doesn't have it for at least 5 weeks, maybe 6 weeks after that. Well, we know in 5 or 6 weeks time period, substantial construction can occur on a job site. And so, as of that date, January 30th, when building number 2 started going up, were the leasing requirements met? And that's what we have to determine. We know, there it is, work on building 6 has started. Okay? I'll go back for 1 second to the leasing requirements page. We know these are the dates of the leases. They're all in it. Coldstone, Anytime, Brown, John, Betty, Z, Grow, Rachel, Rich, and Tony, which we can exclude now from negative covenants, and Donaldson's. On January the 30th, 2006, Coldstone was not yet signed and in effect. Anytime was not yet signed or in effect. Brown was not signed or in effect. Giant Betty was not signed or in effect. Z Grill was not yet signed or in effect. These 3, we know, were dated June 1st, 2006. They couldn't have been signed or in effect. And this is in October of 2006. So as of that date, January 30th, the date they first started vertical construction, they shouldn't have, because the first building, building number 2, wasn't 50% pre-leased yet. Okay? So now let's jump ahead. (7/26/06). At this point, Coldstone is in effect. It has 1,511 square feet. Anytime is in effect. It has 4,995 square feet. And Z Grill, 3,300 square feet. There's a question mark there. Because remember, there's 2 Z Grill leases, one from 06 and one from 08. No one ever explained that. We don't know what was going on there. It may have been in effect, it may not have. We knew they weren't paying rent, because if you look at Exhibit 33 again, it's very telling. The only rents recorded are in that document, Exhibit 33 on the Red Book. And it shows all the receipts, and when they were received, and when they were short, and when they quit paying. But that square footage, if it's all true, 9,806 square feet. That's more than 50%. But we're talking July 26/06. Remember, that's the date of the last draw number 7. Now they need 50%. They're less than 75 unless you include these residential leases, which we have to exclude because of the negative covenant. But they still haven't met the 25%. Remember, 25% had to be office. Those are all retail stores. So even as of July 26, 2006, they hadn't met the requirements of the construction loan agreement. Right? And this is that 7th draw. That was it. That was the last draw. Everyone agrees on that. So, under the contract, were the leasing requirements met? Again, I'm not going to rehash this a million times. You know what they are. I just showed them to you. Black and white. These are their documents, their leases, their exhibits. They didn't need them. Negative covenants, we can't consider any of those related leases because they just don't apply in this case. Unless you just pitch the contract out the window, which is what City Center wants you to do. So ignore the contract. Don't look at the contract. I don't want to be bound by that. I want to be bound by what I said. But only when it's to my benefit. So, did a breach of contract occur? The same standard, the same instruction. Yet another breach of the construction loan agreement. Equity infusion. I went back and forth whether or not to get into the equity infusion debate. You heard from both sides on that issue. You can pull numbers from, there's a lot of numbers floating around. You can pull them from just about anywhere. But if you want to follow along and you want to figure it out for yourself, don't rely upon anyone else's explanation. You don't have to. You can follow the documents. See, and that's the key in this case. You can follow the documents. You don't have to listen to anyone or what they said. You don't have to do it. Just read the documents. Read the black and white, because it gives you a clear, unerring roadmap to the right answer. You don't have to judge anyone's credibility. You don't have to determine if anyone was telling the truth. You don't have to do any of those things. You can just read what's in black and white, and it will give you the answer. So, you can go through, you can read Brian's email where he talks about how that calculation was done, and he came to $450,000, and that's at the bottom of the sworn construction statement, and you can look at that. It's on Exhibit 26 and 27 of those sworns. You can look at, there it is, and it's right there in Exhibit 27, and then there's the 450 at the bottom of the second draw, and you can go through those emails, and you can do your own calculation. You can look at First Indiana's exhibit. You saw how much they approved for work for $971,000. Now they got that down from $971 to $611, and the factors that went into that, $360,000, $258, or whatever that number was for equity into the building, and then it was 170 short, and he needed, or 180 it added up to, and they need 170. You can go on and on and on. Okay? It was a breach. He didn't meet it. We know he needed 210 when he went into the second building. City Center didn't have it. In any manner, he didn't have it. It was a breach, but you know what? You don't even have to go through that numerical mumbo jumbo, because there's too many other breaches to worry about in this case. Now, let's go to let's jump forward. Well, equity infusion, just for a second, that is, it's 1.3G. You've seen it. We've talked about it. You know there was 210 per building, 840 for the whole job. Okay. And then the judge is going to instruct you accordingly. All you have to determine, did they meet the requirements or did they not? Applying the written word. Now, let's talk about these sworn construction statements for a second, because this is very telling too. And again, you don't have to rely on anyone's testimony for this. You can look at the written word, you can look at the documents, you can look at the contracts, you can make your own determination in black and white. Rex Construction, no contract was ever produced. You don't know if they were paid, if they weren't paid. We don't know if they were paid, where the money came from, where it went to. We have absolutely no idea, and no one gave us an explanation for that. There are variances. We went through those. C&D Steel, it's Exhibit 85, and they had a bid price for $88,000. Remember, it was reduced by $3,000 to $85,000 because there were some steel railings or something that was taken off. But we know that was per building. We know that South Lake Electrical had a contract, and at one point it was $72,000, and I think on the next page maybe it's about 100. Yeah, it's $100,000 per building, $600,000 total. And this is rather curious. Remember, Joe Keogh testified that they had underbid the job, but when you look at the sworn construction statement, it shows $1,002,000 as the bid. But there's no contract to match up for that. And the testimony from their corporate representative is they underbid the job for just a tad over $1 million. And what did they do? After they fired South Lake Electrical, they brought in Hawk Enterprises for $600,000. Well, if underbidding the job at $1 million doesn't make sense, how does $600,000 make sense? It just doesn't. There's no rhyme or reason to these contracts or to these numbers. Corellis Roofing, Exhibit 87. They had a contract for about $78,000 per building. You couldn't read it there. It was about $78,000 per building. Okay, and then was our glass. They had a contract. They executed a contract for roughly $372 for 6 buildings, and it looks like $65,000 per building. Okay, so when you look at the sworn construction statements, when you look at 27, all you have to do, and it's kind of small, we can't see it, but just remember, look at 27 and Exhibit 31. And that's the May 12th draw 6, and the November 30th draw number 2. And these figures change. They actually get reduced. And you have to ask yourself, well, if the total contract was, say, $500,000 in November, how did it go down to $325,000 in May? How can that happen? Especially after these amounts have been paid out already. Remember, especially in regards to Rex Construction, who doesn't have a contract, it went from close to $600,000, or right around there, down to about $388,000, after they had already received $549,000. Absolutely no explanation. All you have to do is look at the paperwork, follow the numbers, follow the written word. You don't have to take anyone's explanation for anything. All right. Now, what does the construction contract? 45 minutes? 5 minutes ago? The construction contract talks about what they can use the funds for that the bank is loaning. It's in Article 5.1A. Go to the next slide, please. Year-to-date financials. That's one of the things that Joanne was looking for. And what I'm going to do right here, I think, I'm going to skip forward to the IB&B lien and lawsuit. They don't address this. That lien was filed in May, before that May draw, or right about the time of that May draw. It may have been after. No one notified Fifth Third Bank, and then a lawsuit was actually filed. There's a covenant in that construction loan agreement that says if any liens are filed against this job, or any litigation is filed that affects this job, you have a duty to notify us. They didn't do it. It's just another example of their breach. Joanne tried to work with them. Skip forward a few. Exhibit 90, paragraph 12. She said, look, all right, you're going to do condominiums. You're going to do residential. I'm not saying you can, but give me the condominium documents. Now remember, they're referring to condominiums. Remember the letter we looked at in the first group of exhibits? Back in 2004, November, maybe 2005, not one condominium document has been produced for your review. Where are they? The bank doesn't have control of those. City Center has control of those. Okay? Where are they? You know, just as important as what a document shows is what's left out. And why was it left out? Where are they? It should be something relatively simple to get. No. There are several other issues that I'd love to talk about right now. I just want to leave you with two separate notes. There's a lot of discussion about boilerplate language. I thought it was boilerplate. And specifically, boilerplate on rights and remedies that aren't waived down here in 8.4, and modification and waiver here in 13.2. Remember we looked at those subcontracts entered into between Hawk and its subcontractors, and then the leases themselves between the various planks. They all had provisions which, I guess they agree, those are boilerplate provisions that at this point in time everyone should have known about them because they include them in their own documents. They can't say, I didn't know I couldn't do that when you have it in your own document. All right? I think the sum total and the end result, after you consider all this evidence, and you find out and discuss why didn't they cure in May of '06, why didn't they cure in June of '06, why didn't they cure in July, why didn't they cure in August, why didn't they cure in September, why didn't they cure in October? They were given ample opportunity to do so, yet they chose not to. The bank had no choice.
We're working with 10 minutes.
Thank you, Your Honor. At that point, the bank had no option, remember? If there's no leases, there's no stream of income. The priority of payments, the very last, was to foreclose on the collateral. Banks don't want to own buildings. They want their projects to be complete. They want to be taken out at the end. That's why they make loans, to make money. You don't make money by foreclosing on real estate unless you have no further option. That was done in this case. You heard the building was sold. The proceeds were paid over to Fifth Third Bank to reduce its debt, and it did that. It applied it to the loan. Here's the balance, right here. $6,242,032.70. That's all as of today. Thereafter, it's $506.01 per day. That's the per diem. That's the daily interest rate. I have reserved 10 minutes. I will talk to you after counsel has presented his closing argument. Thank you.
Just request a minute in order to get things changed up here.
Pardon me? Sure.
Please, Clerk, Counsel, on behalf of Mr. Plank, City Center, and myself, I want to thank all of you for your time and attention over the last week and a half. I know you all had other places to be and other things to do. You've given us your time. You've been attentive. You've given us your patience at times, which I know we've tested. But we all appreciate the time you've taken and the service that you've given. You've heard us over the last week, the attorneys out here presenting evidence. You've heard testimony and you've seen the evidence. But you've been in a passive role up until now. When the closing arguments are finished, this is going to be your case. You all are going to decide the facts of this case. You're going to be asked to apply the law that the judge is going to instruct. And the judge is going to give you a number of instructions. There's 20-some instructions of the law. And you saw one of them, Mr. Whittemore put up. It's a basic breach of contract. What does that consist of? A breach of contract, I believe it's instruction number 11. Number 10 occurs when a party fails to perform all of the duties agreed to where a party places itself in such a position as beyond the power to perform that contract. The court's also going to instruct you in a course of dealing. The instruction number 15, the sequence of previous conduct between the parties to a particular transaction, which is fairly regarded as establishing a common basis of understanding for interpreting their expressions and other conduct. course of performance of dealing exists if the agreement of the parties involves repeated actions for the performance by the party. The other party would acknowledge the nature of the performance and opportunity for objection to it accepts the performance or acquiesces in it without objection. The course of performance or dealing is relevant to show a waiver of any term inconsistent with the course of performance. So those are two of the laws we're going to ask you to apply to the facts of this case. Instruction 10 and 15. You're also going to get an instruction on waiving. So instruction 24. A person can waive his or her known right by voluntarily and intentionally giving it up. If City Center proves by the greater weight of the evidence that when the bank acted, it knew it had the right to tell City Center that the bank was not satisfied with the information it was receiving or with the action City Center was taking, so as to put City Center in notice that more information or action was required in order to satisfy the bank, fully understood that right and intentionally gave up that right, then you should decide that the bank waived. So I think those are three important instructions to look at over the course of conduct with this loan. And there's more, but I think all of those can be distilled to one simple premise, kind of a common sense premise, and it was one that Mr. Kelleher waived. How was this bank behaving? Was it acting like a Wall Street bank or a community bank? Those basic concepts. And you heard this was back in 05, 06, real estate's still booming, everybody's doing deals. There's the Wall Street mentality where it's about fees and profits. These banks that think they're above the rules, they can bend and break them to suit their needs of the moment. And there's always a lawyer with an angle to support or try and justify their conduct. And then there's the community banks, who took a consistent approach, tried to be fair and ethical with their customers, and they tried to communicate with them over the long term. And where does Fifth Third fit in the way it handled this transaction? Was it more like the Wall Street bank or the community bank? Now, you've heard evidence about City Center. And City Center started long before Fifth Third came on the scene, about a year and a half before. You heard back in 2004, Mr. Plank was a successful small businessman. He owned and operated Hawk Inc., which was a masonry company. It built a number of the commercial buildings you're familiar with around here. Mr. Plank wanted to establish a new development. And the development he was looking to establish was a mixed-use development. You've heard about new urbanism. It's a development where you can live and work and shop and eat all without having to get in your car. There was no such development in Crown Point or Northwest Indiana at the time. Mr. Plank set up City Center Complex LLC. It was a new entity. And he purchased 15.5 acres of land over here on Broadway. To do that, he established a banking relationship with Standard Bank. He bought land for about $500,000. He borrowed about $400,000 to do it. And this was all back early in 2004. So then he had to go about planning this development. And from the beginning, he contemplated a 9-building development. This would be a mixed-use development. And in fact, you can see this is the illustration he had done to show to the city of Crown Point. Crown Point had commercial building codes and it had residential building codes. It didn't have a mixed-use development code. So Mr. Plank had to present an application. And there's a procedure you have to go through. It's presented, it's reviewed, and it's read, and eventually it goes up for hearing. And you saw this same letter from Mr. Woodward. It's, I believe, tab 33 in the City Center binder. On September 28, 2004, Mr. Plank received B3 zoning for residential living units. And he got that in buildings 5, 6, 7, 8, and 9. Now, from the outset, there's been confusion. 7, 8, and 9 were over here, but 5 and 6 were part of the initial development. 1, 2, 3, 4, 5, 6. And this has been referred to sometimes as 5, sometimes as 6. Either way, this was part of the very initial development. And this wasn't a secret. It went before a public hearing, was even copied to the mayor of Crown Point. The development was approved. And you have in the Fifth Thirds, tab 34, the letter of November 9th approving the mixed-use development. Please be advised that your petition for site development approval for office, retail, and residential development has been approved. And it sets forth some of the things they wanted to do. And once again, this was copied to the mayor of Crown Point. All of this information was provided to the bank. You also heard that the residential use expanded. Again, it was a several-month process. In December of 2005, the residential use was expanded to every building. Mr. Plain completed the site drawings, which I've just shown you. As you can see, the initial drawing was done and completed in 2004, November the 8th, 2004. And it was filed with the city in April 25th, 2005, all long before Fifth Third came on the scene. Mr. Point also had drawings of the individual buildings done. You'll find that in tab 17 of the City Center binder. He had a prototype building with 16 different spots, and you heard these buildings had flexicores, so they were could be easily adjusted. Was it one unit? Was it going to be a whole floor? There's now structural walls to separate these. But in addition to the prototype building that was going to go on 8 of the 9 sites, he also had one special building. That special building was building 5 or 6, as we call it. That was Hawk's Nest. This was a building he was going to operate as a restaurant from the beginning. He had special drawings done for Hawk's Nest in April and May of 2005. It specifically had the name Hawk's Nest on it. And he had the floor plans for Hawk's Nest, page 689, showing restaurant, bar, first floor. And the upstairs, page 690, was residential condo and banquet facility. Those are the plans that were given to the bank. All it was done long before the bank came along. So in the summer of 2005, City Center started construction. And they started construction. Standard was their bank. You heard they began earth moving. They did the site work. The water mains, sewers, the electric, curbs, asphalt. And they began work on the first buildings. Now, it was during this time that Mr. Speck first learned of City Center. And he tells us, there's Joint Exhibit 2, this credit memo. You've heard both sides refer to it. That's an internal bank document. That's not a document that City Center ever saw. That's not a document that City Center ever reviewed or had input on. That's something that was prepared by the bank for the bank. And he told you the site has been visited several times by this officer. Some of the initial site work has began, including the wetlands mitigation and initial excavation. So while City Center is proceeding with this construction, with Standard as their bank, Mr. Speck is going out to see. He's checking out that site. And City Center had its own architect Falk, and that's City Center tab 9, who went out and took pictures. This is his report of October 7th. There was a large billboard the size of this Hawk's Nest sign out there displaying for rent. It had this same picture illustration of the development on it. It told everyone who passed by that this is for retail, office, and residential use. It also showed the concrete work that was ongoing and the site work that was ongoing on October the 7th, before Fifth Third ever came on the scene. Mr. Speck liked the project. The bank wanted this. Kathy Ireland was the banker for Hawk. We've heard it called middle market or middle management, I think it is. And I'm sorry, there it is on Joint Exhibit 2, page 2. Kathy Ireland from Middle Market is referred. And you can see they wanted all of the Plank family business. They wanted everything. They wanted Hawk Enterprises, treasury management. They wanted the multi-card, which Kathy Ireland was introducing. Go on to page 383. They wanted Rich to meet Mike Donovan for investment advisory. They wanted them to meet David Mitchell for private banking. And they also wanted, Mr. Speck wanted the City Center work. And why? It was going to generate a $231,769 fee. That would be their annual fee. And that's in addition to the $61,000 fee that he was going to charge at closing. Bringing this in would generate almost $300,000 in fees. Kathy Ireland also wanted more work. She thought they could get another $6 million loan to the Plank family, which would give another $150,000. And on page 4, you see she is heavily prospecting Hawk Enterprises. City Center, Hawk Enterprises, Fifth Third wanted it all. And why? You've heard about their incentive program. The way these bankers make their bonus is by bringing in new business. Mr. Speck needed to originate $70 to $100 million in new loans a year. This $8.2 million loan was 10% of his annual requirement. He told you how much of a bonus did he make in 2005? $35,000. Ms. Steiger said that the bonus was 35% of her income. So there's a heavy push to bring in new business. We've talked a little bit about the residential. It was in the permits, it was in the zoning, it was in the drawings. Mr. Speck also knew of the restaurant. Now you've seen 3 communications about the restaurant. 2 reference comments by Mr. Plank. Let's take a look at those. Fifth Third tab 44H. This is from Brian to Rich. I know you are going to occupy the second building with a restaurant and banquet facility. That's on September 28th, between Mr. Speck responding to Rich. After Rich has told him they're going to occupy the second building with Hawk's Nest. You also have tab 39. Remember, the bank sent out an appraiser to interview Rich and see the property. And that was reported back to the bank, and John Olson, who was the bank's internal appraiser, and he filed a report on October the 18th, about 3 weeks later. And what did he say? He said under significant observations, apparently the only space with a foreseeable tenant is the subject restaurant, which constitutes 21,600 feet, or 27.53 of the 78,000 square foot center, and that tenant will be the owner of the center. So Mr. Plank told Mr. Specht he was going to occupy the restaurant, and he told the appraiser he was going to occupy the restaurant. What's the email that you keep seeing that's inconsistent? Not email, I'm sorry, the credit commitment memo. Let's take a look at that. Page 2, joint 2, paragraph, page 3. Mr. Specht reports to the other bankers that a restaurateur, the buyer is a restaurateur. They'll operate their first floor as a restaurant, the second floor as a banquet facility. He doesn't tell you who the restaurateur is. Kind of suggests that it's somebody other than Plank, doesn't it? But that's Mr. Specht's statement to his fellow bankers on October the 11th. We know what Rich said. You go back to 44H. He told Mr. Specht, I'm going to occupy the restaurant. That was the email of September 28th.
Read it.
And he told Mr. Olson on October the 18th, that here you go, September the 28th, I know you were going to occupy the second building, not buy it, occupy it, with a restaurant banquet facility. And Mr. Plank's comment to the appraiser on October the 18th, that again, the only foreseeable tenant is the owner, Mr. Plank. So clearly, the bank knew that they wanted to fit. Now, you heard Mr. Plank and Mr. Specht say there was a commitment letter that was sent out, and they sat down and went over it together. That was in Joint Exhibit 1, page 1. And on that letter, Mr. Specht told Mr. Plank this was a letter to refinance the existing note acquisition loan with Standard Bank. Up until that point, all of the work that had gone on had been done with Standard Bank. And it was going to provide construction financing for 4 buildings and 6 sites. And it set forth terms and conditions, the covenants, which are similar to paragraph 1.3. So Mr. Plank reviewed those with Mr. Specht. And what does number 5 say? Each building must be at least 50% pre-leased prior to the start of construction, which includes at least 25% of the office space leased. Additionally, for each subsequent building, the prior building must be 75% leased before construction of the next building can start. So that was what they discussed. Now, why in the world did the bank close this loan if that applied to the construction that was already ongoing? You have the bank's inspector, First Indiana, that went out on October the 22nd, the day after the loan closed. And what was the status of the work? It's Joint Tab 10, look at page 8. The water mains are in with the fire hydrants, the sewers are in with the sewer covers, and more importantly, page 9, you can see there's rebar saved from the concrete, and I apologize for the reproduction quality of pictures. This is what we got. And you can see, more importantly, here's a building with 4 levels of cinder block coming out of the ground, 180 feet long. On page 10, you see a second building with 4 levels of cinder block. Mr. Specht was out at that site on October 22nd. He saw those 2 buildings with rows of cinder block that went for 180 feet. Now, why in the world would the bank close this loan if those covenants applied to these two buildings that had been started before they ever got involved? Well, Mr. Plank told you what his understanding was. We had an agreement for the first two buildings. Building 2 was under construction. Building 5 or 6 was going to be the restaurant. Those were already underway. For the future buildings, we had to have 50% leased, and we had to have the first two at least 75% leased up. And that's consistent with the loan agreement. Look at paragraph 1.3E. It's joint tab 4, the loan agreement, which states that prior to construction of any building, so prior, you already have two buildings that are going. It doesn't apply to those. If it did, why in the world would it close the loan? For buildings 3 and 4, by all means, they had to have the leases in place. But they didn't do anything with buildings 3 and 4. Paragraph 1.3F, prior to the construction of any building. Once again, those apply before you start the building. And what do we know? Month after month, draw after draw. Fifth Third saw the construction, they reviewed the construction, and they approved the construction. If Fifth Third had said, right here, you know what, you can't be building that building, what would the issue be here today? You would have had 4 rows of cinder block that were up. Not insignificant, but not the millions of dollars that we're talking about. The bank approved draw after draw for months for this construction on these two buildings. So then the bank says, well, wait a minute, that doesn't matter. Remember paragraph 8.4 of the loan agreement. So it's found on page 6. No course of dealing between the borrower lender or any failure or delay on the part of lender exercising any right or remedies hereunder shall operate as a waiver of any rights or remedies of the lender, and no single or partial exercise of any right or remedies lender shall operate as a waiver, and so on and so forth. So we can, no matter what, we can always go back and enforce. That's what Mr. Woodward tells you that says. And this comes back to, is this the Wall Street Bank or the community bank? And you heard from Mr. Kelleher. He talked about, what do we use this for? What we use this for, if you have a borrower, his example is taxes. What if you get an extension on your taxes, and you file your taxes a month late? That's a breach of your loan agreement. But with this clause, the bank can work with you. They can accept that late filing, that time. That doesn't mean that you can do it again in the future. If you want to do this in the future and repeatedly, you have to have a written modification. But for that one time, they can accept it. And that's exactly what the bank did here. They had the first two buildings that were already in the ground. They were up, construction had already started. They accepted it. That doesn't mean City Center could build building 3 or 4 or 7, 8, and 9, but these two were under construction. The bank knew it, and they accepted it. So this gets back again. Is this going to be an ethical community bank or a Wall Street bank? We're going to wait for 10 months and then enforce
This is inappropriate argument. It's covered by motion and eliminate. I comment, please comment.